So fundamentally, you are saying that it is not the fault of any Nigerian if they do not get a permanent voter card. So, but they cannot be punished for having the temporary voter card, and they should be allowed to vote.
They should not be punished. They have fulfilled all legal conditions. The legal condition is go and register. And when you register, INEC issues you a temporary voter's card. You have fulfilled your own obligation by the law. So the fact that what the INEC gave you, which is a temporary voter's card, the content of that temporary voter's card is enough for you to be accredited to vote using the BVAS machine. So the failure of INEC, administrative failure of INEC, or logistic failure of INEC to issue you a permanent voter's card should not be visited on Nigerians. See, voting is a sacrosanct duty in democracy. So INEC should not disenfranchise Nigerians because of their own negligence or inadequacies. And that's not the only reason. The major reason here is that the temporary voter's card that is given to Nigerians in itself is enough, totally enough for you to be.
So you're saying Ondo and Edo,
yes,
if anybody has the temporary voter card, by the virtue of the judgment that you got from the Federal High Court,
yes,
they should be allowed to vote.
They must be allowed to vote.
What did the judgment say?
Now, the judgment is basically saying that INEC should not disenfranchise Nigerians. That going by the nature of BVAS and by the nature of the provision of Section 47 of the Electoral Act, individuals who have their temporary voter's card should be allowed to vote. Now, this also happened. When the judgment was given, INEC said it's going to appeal. But INEC the court did not grant a stay of execution to INEC. And the way the law works is that if there is no stay of execution on a judgment given, it becomes operative. So INEC actually disobeyed the court's judgment by going ahead to conduct that particular election against the decision of the court. It went ahead, made an appeal, and the Court of Appeal said that the basis upon which INEC is approaching it, that is academic, because the basis is on the ground of the general election, and the general election is concluded. So the court refused to hear. The court actually struck out the appeal.
So INEC has lost at the Court of Appeal.
Yeah, INEC lost at the Court of Appeal.
And the Court of Appeal upheld the decision of the lower court.
No, the Court of Appeal did not even decide at all.
But it says that they don't have the basis to approach
decide.
it.
Yes, they said they don't have the basis. What the Court of Appeal said is that this issue you brought before us is academic.
But the rest is not lost.
The rest is not lost because the judgment of the Federal High Court still stands. The judgment of the Federal High Court overs on the right of individuals, of citizens to vote, going by the provision of Section 47. The Court of Appeal did not tamper on the judgment. The Court of Appeal did not even say anything about the judgment of the Federal High Court. It neither upturned it, it neither affirmed it. That means that the judgment of the Federal High Court still stands.
Subsists.
Yes.
So in that sense, what you are telling INEC is that INEC has been involved in illegality by disallowing people not to be able to vote.
Right from the general election, INEC has been involved in serious illegality by not allowing people to vote using their temporary voters card. The Federal High Court judgment is still there and subsisting and valid.